So, for our presentation, we are going to be discussing the evolution of Indigenous discrimination. I'm Brynn.
I'm Sam. This case study will examine the impact of global discrimination towards Indigenous peoples due to Western colonialization and the effects of the United Nations Declaration of the Rights of Indigenous Peoples, UNDRIP, has had on the issue of discrimination.
Our case study examines the different ways Indigenous peoples have been discriminated against internationally, specifically looking at where the oppression of Indigenous rights and traditions have occurred, as well as the reasons many of these countries had originally denied the 2007 UNDRIP document, but have later decided to accept it. We will also be discussing the process these countries have gone through during the implementation of the UNDRIP document and the changes in policy against discrimination towards Indigenous peoples, or lack thereof. Since the acceptance of the document in various countries, including Canada and Australia. One issue we'd like to dive deeper into is that these major countries in the world, such as Canada, the United States, and Australia, are globally known for their peacekeeping identity, but they themselves perpetuate discrimination on the Indigenous peoples of their country. The issues we'll be discussing throughout this case study have a strong link to the content we have been focusing on and examining throughout this course, such as the following. Our case study links to the oppression that Western colonization has brought onto different minority groups around the world, specifically Indigenous groups. We will also examine decolonization efforts to support Indigenous rights and culture, specifically through examining the UNDRIP, as well as the goals and impact of the document on the issue of decolonialization. Lastly, we will examine how this document is attempting to work toward a sense of global citizenship, how it is dealing with the impacts of racial and cultural discrimination, and how the document contributes to global ethics as a whole.
What is UNDRIP? As Coates and Fay will explain, UNDRIP sets out the individual and collective rights of Indigenous peoples, including their rights to culture, identity, language, employment, health, and education. With a specific emphasis on self-determination, the document works to strengthen and establish traditions and culture within Indigenous groups that have been suppressed by colonialization. After a report in 1982 on the systemic discrimination of Indigenous peoples, there was an immediate demand for stronger involvement from the UN on such issues. Creation began in 1985 with consultation from Indigenous representatives from around the world. The creation of this document was the first of its kind to be drafted with a strong participation from the population it planned on assisting. After 2 decades of drafting, the UNDRIP was brought before the UN General Assembly in 2007. The UNDRIP was passed with 144 votes. Among the no votes were the United States, Australia, and Canada. As quoted by Enns and Mitchell, the Canadian government said, "Canada has significant concerns with respect to the wording of the current text, including the provisions on land, territories, and resources, on self-government without recognition of the importance of negotiations, and on the need to achieve appropriate balance between the rights and obligations of Indigenous peoples, member states, and third parties. The rights recognized herein constitute the minimum standards for the survival, dignity, and well-being of the Indigenous peoples of the world."
Here we have selected a few points that were written within UNDRIP as descriptors by the General Assembly at the UN as to why the UNDRIP needed to be created. So, reaffirming that Indigenous peoples in the exercise of their rights should be free from discrimination of any kind, concerned that Indigenous peoples have suffered from historic injustices as a result of inter alia, their colonization and dispossession of their lands, territories, and resources, thus preventing them from exercising, in particular, their right to development in accordance with their own needs and interests. Convinced that control by Indigenous peoples over developments affecting them and their lands, territories, and resources will enable them to maintain and strengthen their institutions, cultures, and traditions, and to promote their development in accordance with their aspirations and needs. We chose these excerpts because they, like the remainder of the descriptors throughout the annex of the document, while true, have yet to be resolved. These excerpts in particular are issues that are in constant dispute between Indigenous peoples and their national governments. The General Assembly states that the UNDRIP is a standard of achievement and that it is to be pursued in a spirit of partnership and mutual respect. As we will discuss through this presentation, the UNDRIP has yet to be viewed as a standard of achievement, or even as a document that nations reference wholeheartedly to create policies surrounding their Indigenous peoples.
Indigenous discrimination before 2007. Like referenced above, UNDRIP came to be due to a report written by Jose. The report highlights discrimination of religion, housing, lands, and language against Indigenous peoples. A specific point that we wanted to highlight was within Martinez-Calbo's section on political rights. He said, "It must be stated, however, that even though the law may accord to all persons within a country the right to vote and to stand for election, there are a number of circumstances which may prevent the exercise of that right by all persons to an equal footing. In some cases, the failure of members of a non-dominant group to take full advantage of the right in question may be due to historical factors, or some form of existing de facto discrimination. For example, despite the fact that no individual or group may today be excluded from the law from suffrage, the members of certain non-dominant groups appear to face a number of obstacles in achieving full and free participation in electoral and political processes." It concludes by giving an extensive list of recommendations to the UN as how to rectify the issues the report found. This shows that while Indigenous groups had access at this time to rights that were to make them equal from the dominant society, there were socio-cultural and historical barriers brought on by colonialism that made their access to these rights unequal. As part of Calbo's concluding statement, he says, "Self-determination in its many forms must be recognized as the basic precondition for the enjoyment by Indigenous peoples of their fundamental rights and determination of their own future." As an example, in Canada, RV Sparrow serves as a fleeting example of the discrimination that was experienced by Indigenous populations prior to the creation of any international law. Ronald Sparrow was arrested for fishing with a net that was no longer then permitted on his fishing license. He and his band claimed that his arrest was an infringement of his Section 35, 1982 constitutional rights. 6 years later, the Supreme Court of Canada came to the conclusion that Sparrow's rights had been infringed upon and that his fishing was protected by Section 35. The Sparrow case itself shows that there was a need for international regulatory body that protected Aboriginal rights. Although this case was resolved, it took 6 years of court battles to come to that conclusion. Interestingly, Paul Keel states in 2003 that existing United Nations human rights instruments enshrine fundamental Indigenous rights. But we can see from this example that nothing bound to any nation to explicitly acknowledge Indigenous rights, and like we have discussed in this course, the Universal Declaration of Human Rights is increasingly vague, and nations are able to pick and choose the articles they wish to enforce.
When UNDRIP was adopted in 2007, a few major countries opposed the ruling. Canada, the United States, Australia, and New Zealand were all who originally denied the acceptance on the grounds that the accord was unfair and unworkable. In 2007, Canada's UN ambassador claimed Canada had significant concerns over the declaration's wording on provisions addressing lands and resources, as well as calling on states to obtain prior informed consent with Indigenous groups before enacting laws or administrative measures. In an interview following the rejection of UNDRIP, Indian Affairs Minister Chuck Schral stated that UNDRIP lacks clear guidance for the implementation and conflicts with the existing Canadian Charter of Rights and Freedoms, which already protects the rights of Aboriginal people. Since 2007, all rejecting countries have since become signatories of UNDRIP, but some call into question whether whether their intentions with Indigenous groups have changed. In November of 2010, Canada announced that it would be in full support of UNDRIP. The government stated that their current laws were satisfactory and that UNDRIP would not contribute to any new changing laws. During the same year, New Zealand also reversed their rejection of UNDRIP. In 2009, Australia also became a signatory of UNDRIP, but there have been many criticisms. Many public figures in Australia have resisted the inclusion and participation of Indigenous groups in their governmental processes. Cronin states, "This resistance continues and is evident in the current process for recognition of Indigenous peoples in the Constitution."
Criticisms of UNDRIP. Has there been a change? Article 38 of UNDRIP states in Constitution and cooperation with Indigenous peoples shall take the appropriate measures, including legislative measures, to achieve the ends of this declaration. While the UN claims that they work to enforce UNDRIP, signatory countries like the US, Canada, and Australia continue to face allegations of discriminatory practice against their Indigenous peoples. In Canada, still today, Indigenous women face gender discrimination under the Indian Act. Until recent years, when these women would marry non-Indigenous men, they would lose their Indian status, unlike men, when in the same situation, kept their status. In a specific case, Canadian woman Sharon McGlover filed a lawsuit against the discriminatory practice and extended her plea for support to United Nations. The UN declared Canada's Indian Act to be discriminatory. One of the issues with UNDRIP is that it is very slow working and the legal steps to prevent discrimination towards Indigenous people is not yet in place, even after Canada has 9 years since the acceptance of UNDRIP. In Australia, Cronin, 2007, emphasizes in his article that regardless of the numerous documents that have been accepted into Australian law, Indigenous peoples continue to be discriminated against as recently as 2016. Because the land is legally deemed terra nullius, or uninhabited before occupation, protection for Indigenous rights is limited. Specifically, he states, Indigenous Australians have no political power or distinct constitutional status and therefore lack the capacity to affect outcomes in policy and lawmaking processes.
Protection of Indigenous rights and freedoms is a step towards decolonization efforts because governments are finally accepting the protection of Indigenous cultures and traditions and using the UNDRIP document to support their rights. UNDRIP provides a very specific outline for signing countries. It references self-determination and the allowance for Indigenous groups to practice their traditional ceremonies, educate their children, and speak their languages. Many people argue that the wording of Section 35 in the Canadian Charter of Rights and Freedoms is very vague and can be interpreted in different ways. UNDRIP sets more strict definitions and boundaries about what those rights are and gives Indigenous peoples a specific document to use in court proceedings when they feel their rights have been infringed upon. And specifically, Section 35 states, the existing Aboriginal and treaty rights of the Aboriginal peoples in Canada are hereby recognized and affirmed.
Positive effects of UNDRIP. Since the adoption of UNDRIP, governments are implementing legal action towards taking measures necessary to ensure the laws of the country are consistent with the UNDRIP Development Action Plan. Since the adoption of UNDRIP in Canada, the government began to move towards including the goals of UNDRIP into legal action through steps towards passing Bill C-262. The bill requires the federal government to take all measures necessary to ensure that the laws of Canada are consistent with UNDRIP and develop a national action plan to do so in consultation and cooperation with Indigenous peoples. A step in the right direction. In general, UNDRIP has been a push for many countries to begin to take more seriously into consideration the voices and rights of Indigenous peoples around the globe. In addition to UNDRIP, Indigenous rights are being recognized and enshrined in new laws, international frameworks, and constitutional agreements. Guided by the principle that no one is left behind, Indigenous peoples are a priority under the UN's 2030 Agenda for Sustainable Development. UNDRIP is also being increasingly incorporated into domestic laws and has started getting the gears turning in many countries to acknowledge the importance of respecting and honoring the rights of Indigenous peoples. Countries in South America have been bringing UNDRIP goals into their legal systems. Countries in Europe, such as Greenland, has granted greater self-governance to their population of indigenous peoples, where the majority of the population is Inuit. Countries in Africa, the Republic of Congo, the Central African Republic, Kenya, and Namibia have began taking steps to recognize indigenous peoples.
In the Xanthakian Allen book, Elsa Stamopolo states a tremendous success that has been brought forth by UNDRIP. Specifically, she mentions that many of the articles included in UNDRIP should have been included or even replaced some articles within the Universal Declaration of Human Rights. She states further that the principles of non-discrimination and equality must guide the state's actions in its obligations regarding the cultural rights of Indigenous people. Throughout our research, we have discovered the importance for an international organization like the United Nations to recognize the rights of Indigenous peoples. The signatories are now bound by their commitment to recognize and affirm the culture and traditions of the Indigenous peoples in their country. However, the countries mentioned have still participated in discriminatory practices since their signing, thus proving that while an international document is an important move towards Indigenous international recognition, more work still is to be done to relieve Indigenous populations of the still present impact of colonialism.